What if Judge Amy Coney Barrett, known for always asserting the power of the law, found herself powerless against a press secretary? This was the moment when Judge Amy Coney Barrett tried to jail Caroline Leavitt, only to realize she's a legal genius. A showdown that left even the sharpest legal minds in the court stunned. But how did a young press secretary manage to outwit the Supreme Court? What made her so confident that even the most experienced justices were forced to reconsider their stance? Imagine this. You're a press secretary for the White House, and one day, you find yourself facing off against the highest court in the land. Now, imagine that court doesn't just disagree with you, they want to throw you in jail. Sounds like a nightmare, right? But that's exactly what happened when Caroline Leavitt, a press secretary with a sharp legal mind, dared to criticize the Supreme Court. On one side, you had the formidable Judge Amy Coney Barrett, who has always stood as an unshakable defender of judicial authority. On the other side, a 28-year-old press secretary, armed not with power but with her ability to read and apply the law like a seasoned attorney. The scene was set for an epic battle of wits. Why would the court go so far as to consider jail time for a press secretary simply speaking her mind? Was Leavitt's criticism truly crossing a line? Or was it something much deeper? And most importantly, could the Supreme Court be wrong? As Leavitt stood before the justices, the stakes couldn't have been higher. One wrong move could have meant the end of her career. But what no one saw coming was her brilliant legal defense, one that would leave the justices questioning their very stance. The press secretary wasn't just defending her words, she was challenging the very limits of free speech. So how did this fiery confrontation unfold? What made the justices rethink their entire approach to the situation? And could one press secretary change the course of history with nothing but her legal knowledge? The stage was set. The legal and political worlds watched with bated breath as Caroline Leavitt, the White House press secretary, found herself at the center of a dispute that no one had anticipated. It wasn't just another White House briefing. It was an explosive confrontation between the executive branch and the judiciary. Leavitt had recently made controversial comments about a Supreme Court ruling, sparking outrage within legal circles. She had publicly criticized the court's interpretation of constitutional law, claiming it was a fundamental misreading of precedent. It wasn't the first time an administration official had criticized a Supreme Court ruling, but the stakes were far higher this time. The rhetoric had caught fire, and the court, led by Justice Amy Coney Barrett, wasn't about to let such criticism slide. What followed was nothing short of a legal showdown. Judge Barrett, known for her no-nonsense approach, quickly escalated the issue, summoning Leavitt to face contempt proceedings. What was supposed to be a simple legal reprimand turned into something much bigger, an all-out constitutional battle. For Leavitt, this wasn't just about defending her words. It was about defending the very idea of free speech against the powerful institution of the court. But could she stand her ground? Would her legal expertise, unexpected and largely unknown, be enough to challenge a Supreme Court justice who had spent years interpreting and shaping American law? The tension was palpable. Inside the courtroom, Leavitt stood poised, yet every word she uttered could make or break her case. Was she simply a press secretary in over her head? Or was she, as some had started to suspect, a legal genius ready to outsmart the nation's highest court? The odds were stacked against her, but her resolve was unwavering. As the courtroom door slammed shut, the legal world held its collective breath. What would happen next? Would Leavitt's sharp legal arguments be enough to protect her, or would the full weight of the court come crashing down on her? No one knew, but this was about to become a battle for the history books. As Caroline Leavitt stepped into the Supreme Court, she could feel the eyes of the entire nation upon her. But it wasn't just the weight of the media attention that weighed on her shoulders. This was no ordinary day. The stakes were sky high. Leavitt, a young White House press secretary, was about to face off against the towering figures of American jurisprudence, led by the powerful and often unflinching Justice Amy Coney Barrett. It was supposed to be a routine disciplinary hearing. Leavitt had made waves with sharp criticisms of the court's recent ruling, and now the justices were calling her in to answer for it. Everyone expected her to back down, maybe apologize, and then quietly leave the room, but they had no idea what she was capable of. As she sat before the justices, the tension in the room was palpable. Justice Barrett, known for her firm commitment to the law, didn't mince words. She came straight to the point, accusing Levitt of undermining the very fabric of the judicial system with her remarks. The room was silent as Barrett demanded an explanation, her gaze unwavering. Levitt, however, remained calm. She wasn't just a press secretary, she was a sharp legal mind with years of study under her belt, although few knew it. She took a deep breath and began, not with an apology, but with a challenge. She pointed to the court's own precedents, citing landmark cases that supported her right to criticize the court's rulings. The justices, including Barrett, sat in stunned silence. This wasn't the response they had expected. Barrett tried again. "Your position as a press secretary," she said, "carries the authority of the executive branch. Your words impact the public's perception of the court. Don't you see the damage you could do?" Leavitt's answer was measured yet firm. She acknowledged her role but refused to back down. She cited specific cases where the executive branch had criticized judicial decisions, none of which led to contempt charges. The tension grew as she quoted directly from legal texts, using the court's own language to make her case. One by one, the justices began to shift uncomfortably in their seats. This wasn't the usual back and forth. Levitt was holding her ground, and each point she made seemed more convincing than the last. Justice Barrett's confident demeanor began to falter as she listened. How could a press secretary, someone so young and relatively unknown, command such an intimate understanding of constitutional law? At this point, the room had gone from a courtroom of formal exchanges to a battlefield of ideas. Levitt wasn't just defending herself. She was showing the justices that the boundaries of judicial power were not as absolute as they thought. And with each word, she was gaining ground. Leavitt's calm confidence contrasted sharply with the rising tension in the room. She knew she wasn't just fighting for her own freedom here. She was fighting for the principle that even the highest court in the land must be subject to criticism. The stakes couldn't have been higher. Would the justices back down and reconsider their stance on the power of the executive branch? Or would they continue with the proceedings, risking a backlash from the very public they were meant to serve? The tension in the courtroom was electric as Caroline Levitt stood tall, facing the highest court in the land. Judge Coney Barrett, prepared for a standard contempt case, was now faced with a young press secretary who, instead of apologizing, had turned the tables with a surprising legal defense. What happened next was nothing short of extraordinary. Levitt wasn't just defending herself, she was schooling the court on the very laws they helped shape. With quiet confidence, she began citing landmark constitutional cases, blending them seamlessly into her argument. She didn't just challenge the charge against her, she presented a First Amendment defense that left even the most experienced legal minds in awe. "I'm not here to attack the court," Levitt calmly stated. "I'm here to defend a fundamental right, the right to criticize, to question, and to engage in free speech, especially about the judiciary." It was a bold statement, and it was clear Levitt knew exactly what she was doing. She wasn't just quoting cases, she was turning the very structure of the case on its head. As she referenced decisions that dated back decades, it became apparent that her knowledge of constitutional law was not only impressive, it was groundbreaking. She quoted directly from cases involving executive powers, citing precedents where the executive branch had openly criticized the judiciary. It was clear now. This wasn't just a political battle. This was a constitutional one, and Levitt was playing the game like a seasoned lawyer, not a press secretary. The justices, initially skeptical, started to lean in. They were listening, truly listening. Levitt's command of the law was something they hadn't expected. They had thought they were facing a simple political figure, but now they were witnessing someone who could match wits with the sharpest legal minds. As the session ended, it was clear that the court had been forced to confront a new reality. What had begun as a typical hearing had evolved into an examination of the very principles of free speech and judicial accountability. Levitt had demonstrated that legal genius doesn't always come from a judge or professor. Sometimes it comes from unexpected places. The atmosphere in the courtroom had shifted drastically. The tension, once thick with skepticism, was now replaced with a sense of realization. Caroline Levitt, a figure many had expected to back down or apologize, was instead standing firm with a clear, commanding presence. It was a moment that not only caught the justices off guard, but also forced them to confront their own understanding of constitutional boundaries. For Judge Amy Coney Barrett, the situation had become more complex by the minute. Initially, the contempt case seemed straightforward. Leavitt's remarks about the court's ruling had sparked outrage, and Barrett had expected a quick reprimand. But what happened instead was a display of legal expertise that many did not anticipate, least of all the court itself. Leavitt, with steady hands, had turned what should have been a humiliating moment for her into an opportunity to showcase her deep legal knowledge. It wasn't just her argument that made an impact, but her approach. She didn't just present her defense, she redefined the discussion, framing the issue not as one of personal attack, but of fundamental constitutional rights, specifically the right to criticize the judiciary. As the session progressed, the justices found themselves grappling with a crucial question. Could they, in good faith, continue to uphold the contempt charges when the very foundation of the case had been dismantled? Leavitt's defense wasn't just based on academic theory. It was a practical application of the law, connecting the executive branch's right to criticize the court with long-established legal precedents. Justice Barrett, who had entered the proceedings with a clear objective to issue a swift ruling, found herself now second-guessing her position. She knew that Leavitt wasn't wrong. The case was about more than just one person's comments. It was about the larger issue of executive power, judicial independence, and the public's right to engage in debate. The court, in its deliberation, had to confront a dilemma. If they proceeded with contempt, they risked undermining the very principles of free speech they swore to uphold. Leavitt wasn't just defending her right to speak. She was teaching the court a lesson in constitutional law, and the justices, especially Barrett, were forced to take notice. The dynamic had shifted from one of authority and reprimand to one of dialogue and respect. This was a turning point, a moment where the line between judicial authority and free speech was drawn, not by the court, but by the very person they had summoned to answer for her words. As the session ended, Leavitt's composure and legal insight had done what no one expected. It had put the court in a position where they had to rethink their approach, their authority, and their understanding of constitutional rights in the modern age. What had started as a simple disciplinary proceeding had transformed into an open conversation about the balance of power in American democracy. The turning point had arrived, and with it, Leavitt had proved that even the most unexpected voices could hold the power to shape history. The tension in the courtroom was palpable, as Caroline Leavitt's fate hung in the balance. What had started as a simple contempt case had evolved into a landmark constitutional showdown. The entire nation, and particularly legal experts, were on edge, waiting for the Supreme Court's ruling. Behind the scenes, the justices were deep in deliberations. The questions they faced weren't just about Leavitt's actions anymore. It was about the larger principle of free speech and its boundaries when directed at the judiciary. Could the court afford to punish a White House press secretary for speaking out against its decisions? Or, as Leavitt argued, was it the court's duty to protect the rights of individuals to criticize its rulings? The weeks leading up to the decision were filled with uncertainty. On one hand, the court had to consider the potential damage to its credibility if it appeared to be too lenient with government officials who openly criticized it. On the other hand, they had to carefully weigh the constitutional implications of restricting speech, especially when that speech was aimed at holding powerful institutions accountable. Finally, the decision came, and it was a historic one. In an unprecedented 9-0 ruling, the court sided with Leavitt. The justices ruled that no contempt charges would be pursued, citing the significant First Amendment concerns raised by Leavitt's defense. The court emphasized that robust debate and criticism of the judiciary were essential to a healthy democracy. Justice Barrett, in her concurring opinion, made it clear, while the judiciary had the right to safeguard its proceedings, it could not silence legitimate criticism. A democracy, she wrote, must allow space for public discourse, even when that discourse challenges the court itself. For Leavitt, the ruling was nothing short of a triumph. She had not only avoided jail time, but had also secured a major victory for free speech. Her quick thinking and deep legal knowledge had completely turned the tide of the case. What had initially seemed like a public relations nightmare for the administration had become a resounding win for the protection of constitutional rights. When Leavitt addressed the media after the ruling, her message was clear. This victory isn't just for me. It's for the preservation of the right to question, debate, and hold our institutions accountable. Her case, once viewed as a liability, had now become a symbol of legal brilliance and a turning point in the relationship between the executive branch and the judiciary. The outcome would have lasting implications, influencing future debates over the balance between free speech and judicial authority for years to come. In the end, the confrontation between Judge Amy Coney Barrett and Caroline Leavitt was far more than just a legal dispute. It was a historic moment that revealed the real power of free speech and the importance of standing up for constitutional rights, even when faced with the mightiest institutions. Leavitt's defense wasn't just about defending her own words. It was about defending the very essence of democratic debate. Her argument wasn't one of confrontation, but one of respect, a respect for the Constitution, for legal precedents, and for the role that criticism plays in the health of democracy. The question that many were left asking after the dust settled was, is the right to challenge and criticize the judiciary protected even against the most powerful forces? The answer, after this momentous showdown, seemed clear. Yes, the law does protect it, and perhaps even more crucially, the people who stand up to protect these rights are often the ones who change the course of history. Caroline Leavitt might have walked into that courtroom as a press secretary facing contempt charges, but she walked out as a symbol of courage, intelligence, and legal brilliance. For all of us, this moment serves as a powerful reminder. The power of the law belongs to those who understand it, who fight for it, and who respect it enough to question it when necessary. Leavitt's words weren't just words. They were a testament to the resilience of free speech, an essential pillar of American democracy. So, what does this mean for the future? Will we see more individuals like Caroline Leavitt rise to challenge powerful institutions? Will we see more battles for the freedom to question, to criticize, and to grow? The future remains uncertain. But one thing is sure, this legal clash has ignited a spark that will resonate far beyond the walls of the Supreme Court. This isn't just about one individual's victory. It's a victory for free speech, a victory for legal rights, and a victory for all of us who believe in the power of democracy. Now that you've witnessed the unforgettable showdown between Judge Amy Coney Barrett and Caroline Leavitt, it's time to hear from you. What do you think about the power of free speech in legal battles? Was Leavitt's defense a game changer in how we view the relationship between the executive and the judiciary? Let us know your thoughts in the comments below. Your opinion matters. If this story inspired you, don't forget to hit that like button to show your support for courageous individuals who challenge the system. And if you haven't already, subscribe to our channel so you never miss another deep dive into the world of law, politics, and history. We bring you stories that matter, ones that challenge the status quo and leave you thinking long after the video ends. Also, share this video with your friends who would appreciate seeing how one person's legal brilliance changed the course of history. Let's get this conversation going and keep the debate alive. Don't forget to ring that notification bell so you're the first to know when we drop our next jaw-dropping analysis. You won't want to miss it.